Nobody read it, but it's good. I will read it. Not much.
Senator Booker.
Thank you. Thank you, Mr. Chairman. Judge, in a 1999 interview with the Christian Science Monitor about the Rice case, you discussed with Senator Hirono a little bit, but you said, and I quote, "This case is one more step along the way in which I see as an inevitable conclusion within the next 10 to 20 years when the court says we are all one race in the eyes of government." It's been about 20 years now, or about 6 months away. Do you think that you were wrong at that point, that racial discrimination in America would be over by 2019?
I think that was, Senator, an aspirational comment, and one that, to your point, of course, I've said in my decisions, as you and I have discussed, that the march for racial equality is not finished, and we still have a lot of work to do as a country and as a people on that. So
I appreciate that. I really do. But I want to know what you were thinking in 1999 that would make you make such a bold aspirational comment that, hey, in 10 years, the court can view us all as one race. What was going on in the 1990s that led you to have that belief?
hope.
Okay, because you and I know, you and I are both aware of where the trends were going in the 1990s. This was the period where the drug war was in full blare, where the prison population exploded. Since 1980, we've been up 800% in the federal prison population. The massive increases in racial disparities of incarceration. Blacks constitute roughly 13% of drug users, but were 46% of those that were being jailed for drug offenses. Even our schools in the 1990s were becoming more segregated. And so your brief in the Rice case invoked Justice Scalia's argument that we should be, quote, one race. And this, let me go on with the Scalia quote, because he said that government can never have a compelling interest in implementing race-conscious programs that seek to address this nation's wretched history of racial discrimination. He said never. He said that race-conscious programs, I'm going to quote him now, are racial entitlement. Now, do you think that someone who wants to remedy the fact that they could not get a loan from the Fair Housing Administration because of the color of their skin is racial entitlement, or are they seeking racial justice? Do you think someone, a person who tries to remedy the fact that they were denied the chance to go to college under the GI Bill because of the color of their skin is seeking racial entitlement, or are they seeking racial justice? So to be specific with Scalia, do you agree with Justice Scalia, who you reference in your brief, that it's never permissible for the government to use race to try to remediate past discrimination to try to achieve justice?
Senator, that was a brief for a client, first of all, so I was not saying something in my own voice particularly there, so I'm writing a brief for a client.
But if I can correct you, sir, you said it's just a brief for a client, but you seem to invoke Scalia's one race theory quite often. You invoked Justice Scalia's one race theory to a reporter. You again mentioned it in the Wall Street Journal op-ed you wrote around the same time, and you cited his opinion, yes, in this brief. Are you saying that you do not share Justice Scalia's beliefs about this idea that people who are seeking to address past discrimination, past harms, that they are seeking racial entitlement?
I think, first of all, the Supreme Court precedent allows race-conscious programs in certain circumstances. So the precedent on the Supreme Court, as you know, Senator, is different. I was writing a brief trying to cite all the principles from the different cases that would support the brief. But to your point, there's when you're trying to remedy past discrimination as a general proposition, you're seeking racial equality and seeking to remedy both past discrimination and the lingering effects.
So you disagree with Scalia that he says it's never permissible for the government to use race to try to remediate past discrimination to try to achieve justice. You disagree with Scalia?
The Supreme Court law.
I know what the precedent is. I know what the law is. I'm asking what you believe. Do you agree with Scalia that, again, that it is never permissible for government to use race to try to remediate past discrimination to try to achieve justice, that that's racial entitlement?
That position has never been adopted by
I'm asking what you believe, sir, not the Supreme Court.
Okay. The term I used was that what you're seeking is equality, equal, and what.
And right, so if you're seeking equality, I appreciate you grant that. Is it never permissible for government to use race to try to remediate past discrimination?
There are a couple of things that the Supreme Court's pointed out in its case law.
And again, I know the Supreme Court case law. Maybe I can approach this in a different way.
Okay.
The aftermath of Katrina. In a case brought by plaintiffs in New Orleans who challenged the way government provided grants to homeowners as having a discriminatory impact on African Americans, you joined the minority in denying them relief. If the findings had shown that the grant program systematically disfavored African Americans, would a government effort that uses race to remedy that disparity be unconstitutional? In other words, do you believe that all such efforts that the government using those efforts to amount to what Scalia called a racial entitlement? I'm trying to figure out if you agree with that point that Scalia is making.
Senator, first of all, I approach questions like you are asking with a recognition of two things. One, the history of our country, and two, the real world today.
Yes.
And I try as best I can to understand both the history of our country on that issue and the real world today. So I'm coming at it from that perspective. You're asking a question, I think, about specific remedies for discrimination, and there's a lot. I'm a judge, as you know, and so I have to follow precedent, and the precedent allows remedies in certain circumstances.
And again, sir, I've heard you use that with a lot of my colleagues, and I know what precedents are, especially dealing with a lot of very important Supreme Court issues. I'm asking about your opinions because your opinions matter, what you've saved matter. Let me give you an example. In April in 2003, you wrote regarding a program designed to benefit Native American small businesses by saying the desire to remedy societal discrimination is not a compelling interest.
That's what the Supreme Court has said, and
hold on, the Supreme Court said that the desire to remedy societal discrimination is not a compelling interest.
the Supreme Court has let's go to Bakke, for example.
I'm going to get to Bakke. Okay. Just answer this question. Yeah. Do you still believe, this is what you said, that race can never be used to remediate clearly proven discrimination? If it's clearly proven discrimination, I'm just using an absolute. Do you still believe that it can never be used?
Well, I think the Supreme Court has said it can be to remedy.
I know what the Supreme Court, but what do you believe, sir?
Well,
come on, you know the history. You've recited it numerous times.
What I would say, look, I have trouble departing from the Supreme Court precedent and saying.
But you don't. You opined about it in emails. You've opined about it in Wall Street Journal articles. I've heard you opine about these things in race. You just can't say right now what you believe.
Well, a couple things, Sarah, just to back up. Lawyer for client in the email you're reading as well.
Christian Science Monitor article, Wall Street Journal, your comments to a reporter. Let me approach it this way, because you're not answering the question, but let me see if I can approach it in a different way, now getting to some of the things you were talking about. The Supreme Court has said for decades, this gets us to Bakke. Yeah. The Supreme Court said for decades that institutions of higher education have a compelling interest in student body diversity, and that race can be used as a factor, not the only factor, but a factor in admissions if it is done so in a way that is narrowly tailored to serve that interest. You said, the court said this in Bakke, you and I know these cases, said it in Grutter in 2003, Fisher most recently in 2006. The simple question here is, do you believe these cases were rightly decided?
Senator, there are important precedents of the Supreme Court, and as Justice
I didn't ask you if there were precedents. I've heard you go through this before. Do you, sir, if you can't answer it, just say it, Corey, I can't answer this. Do you believe that those cases, you say Marbury versus Madison was rightly decided. You said that. You said Brown versus Board of Education, rightly decided. And by the way, desegregation cases could come before the Supreme Court. Do you believe that these cases, yes or no, do you personally believe they were rightly decided?
Senator, I am following the precedent of the set by the 8 justices currently sitting on the Supreme Court, and to put it in the terms of Justice Kagan, who was asked a lot of these same questions. It would be inappropriate to give a thumbs up or thumbs down on.
Yeah, but sir, there's a distinction between you and Kagan, you and Ginsburg on these issues, because let me just tell you the distinction.
Roberts, Alito, Gorsuch,
and I'm going to tell you the distinction between that excuse you're using with many of my colleagues. And the distinction here is none of those nominees had voiced personal opinions that government should refuse to defend these kind of programs. And let me give you an example. You wrote in an email about Adirondack versus Mineta, a case that involved benefits to minority-owned businesses, you wrote that the government should file a brief saying that the program is unconstitutional. And let there be no confusion, sir. You went on to write that, in fact, this is my personal opinion. And so you said that then. My question is do you still think a diverse student body is a compelling interest? You opined on it then. You wrote it then. Right. What do you believe now?
So a couple things there, Senator. First of all, the Adirondack case is in the context of contracting. The Bakke case is in the
So you think that those cases, using race to remedy past discrimination, is unconstitutional? That's what you wrote then.
Well, in light of the precedent of the Supreme Court representing a client in that case. And I go through, I think the email you're referring to, I go through, actually, the SG should make a recommendation first that this should not be a White House dictated answer, and the Solicitor General is ordinarily, I think if you're referring to the email I'm thinking of, but in any event, I think, as you know, and I just want to reiterate, there's precedent in the higher education context, in the contracting context, that are somewhat distinct, and those precedents have been applied by judges. And my record on race discrimination cases, I'm happy to talk about my cases, the E.C. Ito, the South.
But you're not happy to talk to me about the opinions you've expressed in the past. Do you still hold those opinions now?
Well, that's what I wrote then as a lawyer for a client.
But you said that, again, that is in fact my personal opinion.
That's before the case is decided and subsequent.
So you expressed a personal opinion on this issue then. Do you still hold that same opinion now? That's unconstitutional.
I think you're taking, I believe, respectfully, personal opinion out of context. Their personal opinion about what the government position, so personal recommendation, because I said, the distinction there is I said the Solicitor General should first make a recommendation and then the White House should respond, or the President. As to personal opinion, it was not my personal opinion, Kavanaugh, it was what the government's position recommendation would be based on President Bush's
stated policy. Seems that you were pretty clear there what your personal opinion was.
Well,
let me approach it again.
I don't want to.
Sir, we don't have to go back and forth. I want to ask you a simple, direct question. Do you think having a diverse student body is a compelling government interest? Do you believe that? Do you think having it's not a complicated question. Do you believe having a diverse student body is a compelling government interest?
The Supreme Court has said so, and my efforts to promote diversity, I'm very proud of.
But I know what the law is now.
No,
I'm worried about what the law is going to be, sir, when you get on the court and have the ability to change those precedents. But let me go back to your words. I just want to ask you about your words and maybe give you a chance to explain something else, because you haven't answered my question, and I understand that you're going to stick to that. You've also written that an effort designed to benefit minority-owned businesses, an effort to try to give them a fair shake because they had been historically excluded, and these are your words now, used a lot of legalisms and disguises to mask what is in reality a naked racial set-aside. That's what you said. That's how you referred to it.
What are you reading from, Senator?
Sir, I'm reading from an email dated August 8th. These are your words, but I don't need to know about.
Can I get a copy of it?
You certainly can, but let's ask you what you believe now. I'll leave aside then. Yeah. Okay, you said it, but you wrote it, but my question is, what are your views right now? Do you believe that government efforts to promote racial diversity are a naked racial set-aside? Those are loaded words. Do you believe that now, sir?
The government efforts to promote diversity in the higher education context are constitutional, and I've made clear my own personal efforts to promote.
But you referred to it in the past, sir. You referred to minority-owned businesses trying to get a fair shake after historically being excluded. You call that which is very powerful.
I don't have the email, Senator, so I'm a little.
So have you ever used the term naked racial set-asides? Do you remember ever using that term?
That would, if you're saying there's an email, but I would like to see an email if I'm getting questioned about an email.
Okay, I'm going to ask my staff to provide you an email while I move on.
I have promoted diversity in law clerk hiring and made a big difference in that.
Sir, you've told me about the diversity you promoted in law clerk hiring, and I'm so grateful for it. You've told me a lot of things about the diversity that you personally have practiced in your own life. I really, really appreciate that. I'm not asking you about the 5 black clerks that you have. That's good. I'm seeking You're seeking a position on the highest court in the land that's going to affect millions of people. You've expressed opinions about these subjects to the media, to the press, in speeches, in past emails, but you're not willing to say if you still hold those positions that you held before. And I want to just move on to specifically something that you have expressed opinions in some of your cases as well, sir, and that's the issue of racial profiling. You once discussed the use of racial profiling after 9/11 with your colleagues in the Bush White House.
Can I see the email?
What's that, sir?
Can I see the email?
Yes, I will get you the email, but there was
But I can't answer if I.
I'm going to ask you about your views now, sir, and I'll provide the email, but I'm more interested in your views right now, before you may be confirmed as a Supreme Court justice. There was a debate going back and forth, and one of your colleagues said that there was a school of thought in the administration that if the use of race renders security measures effective, if using race renders security measures effective, then perhaps we should be using it in the interests of safety now, in the long now and in the long term, and that such